So we're pleased to have Darren with us here. Darren is a senior lecturer in law at the University of Essex, where he is a colleague of Marina's. In 2013, he set up one of the UK's first animal law undergraduate modules, which has since seen hundreds of law students learn the basic principles of UK and international animal protection law. Darren has also published numerous articles, books, and book chapters on the subject of animal protection. And today he's going to be talking to us about animals and the right to life. Darren, welcome to the conference.
Thank you very much for having me, and apologies if I made certain people's hearts stop thinking that one of the presenters wasn't going to be here. I had to, anyway, I'm here now, so yeah, thank you for having me. It's very nice to be here, and I hope in some ways I haven't oversold the next probably 20-25 minutes by even giving it a title. I didn't think that some random musings on animals and their life was going to be sufficiently weighty. So I called it historical relativism, rights, discourse, and the law. Now, I suppose the first thing I want to say is if I stray into the subject of rights, bear with me. I wake up each day deciding whether today do I believe in rights or am I more kind of utilitarian. I've never quite 100% decided whether I'm totally in favour of rights. Certainly this talk isn't going to be a deep and thorough investigation into rights theory. We may have some, but mainly it's just going to be about the musings I've had, probably since I first became involved in animal protection from an academic point of view, is that this idea of the right to life. I've been involved academically with animal protection for many years now, and we treat almost welfare as being the thing we talk about. Welfare, well-being, the conditions in which we keep animals, sometimes, in the case of happy, of course, the reasons why we keep animals. But as an academic discipline, certainly in law, I'm aware that in other disciplines, animal lives are very much talked about. I certainly don't propose to go into sort of too many ethical debates, too many philosophical debates, and biological debates. I'm certainly not competent to go into any of those areas. But for lawyers in particular, we focus on welfare, well-being, and the reasons why we may legitimately subject animals to harm. And we pretty much ignore an animal's right to life. Maybe it's because of the phrase right to life. It's certainly loaded. It's a loaded phrase, but certainly we accept almost without question that an animal can lose its life just because we decide that this is the case. Now, a couple of caveats, of course. Certainly in Section 9 of the Animal Welfare Act 2006, Section 9(4), nothing in this section applies to the destruction of an animal in an appropriate and humane manner. So you have your obligation under Section 9 to provide for the welfare of the animal, provide for its needs in terms of housing, its diet, its need for company where necessary, etc., etc. But if you decide that you do not want to do this and you have your animal destroyed in an appropriate and humane manner, no offence has been committed. And it's rarely ever questioned. Now, that got me thinking, why? Why is this the case? Why have we got to the point where we've got 30 or 40 people from academia and hundreds more worldwide who don't really ever talk about this too much from a legal perspective? And so this is where the historical relativism comes in. And I thought, well, go back. We could have started this with the opening passages of the Bible. in the beginning God created man, and man was given dominion over animals. We could go back as far as that, but we've only got half an hour, so I'll skip forward about 1780 odd years to Bentham. Now, of course, we all know Bentham and his famous, the question is not whether they can talk, not whether they can reason, but can they suffer? Very famous quote, brilliant for a t-shirt if you want to sort of launch a campaign or something like that. But this, for me, is kind of where we begin the legislative unravelling, or the legislative protection of animals. It evolves over a couple of hundred years, but for me, this is kind of start point. Now, I know there were many discussions prior to Bentham, many issues bubbling on in the background, but certainly Bentham's utility calculus, where we ask what the benefits are and what the harms are, weigh them up in a utilitarian perspective, and decide whether the suffering was in fact necessary. We've all sort of we know about the unnecessary suffering test. It's there and has been almost since the beginning of animal laws. What Bentham, I think, was doing here, and Joshua gave a trigger warning in his speech, and I'm going to give one now. I may swear at some point in this. I think Bentham was saying, all this Cartesian nonsense, that's a better word, all this Cartesian nonsense, as witnessed in his can they talk, can they suffer, this is all nonsense. All this Kantian moral agency, moral patience, it's all nonsense. When we're talking about the treatment of animals, the only thing we need to focus on is what we do to them, and that's caused them harm. So, clearly, if the only thing that we do to them is cause them harm, we need to know what impact does this have on the animals. That's where we get the can they suffer. He's talking just about harm. And he goes on in this relatively short passage that he devotes to the question of animals, and does discuss their ongoing right. Obviously, Bentham was absolutely no way a rightist, but he talks about their so-called right to life. And he says, well, actually, if death at human hands may be speedier and less painful than would otherwise await them in the inevitable course of nature. He's talking about wild animals here, but later goes on to talk about domesticated animals as well. And he says they are never worse for being dead, which I'd argue is possibly debatable. I don't know. But certainly that was a start point for those who wanted a reason to protect animals. They had the hook. Can they suffer? Yes, therefore this suffering must be factored into the utility calculus. Once we've factored it in, then we've got to this unnecessary suffering test, and only those actions which cause animals harm but are necessary for human betterment can be allowed. But we're not interested in animals' right to life, because they're never worse for being dead. And, frankly, if we kill them in a humane and painless way, we're probably doing them a favour. Because, I've often thought, which has kind of put me in a moral dilemma, would I rather be a lion in the wild or a lion in a zoo? And clearly I'd rather be a lion in the wild. Would I rather be a lion in the last 5 years of its life, a male lion in the last 5 years of its life in the wild? It might not be that nice. Starvation kind of setting out. Anyway, that's a big aside. What we know is that back in Bentham's time, animals' lives were pretty painful things. They were not treated particularly well. Now let's skip forward a couple of years. And for me, I've written on this a couple of times before on the Ereskin Bill. Now for me, the Ereskin Bill was setting out the scene for the next 100 years at least, possibly the next 200 years. Now, Lord Erskine, 1809, he presented a bill to Parliament which was Wide-ranging, very wide-ranging. If you ever read his speech available in Hansard, you'll see he talks about a lot of the areas in which we should be protecting animals, a lot of the current practices of animal abuse that should fall within a legislative prohibition. Very wide-ranging, very passionate speech. I think sometimes I think today's politicians could sort of take a leaf out of the Victorian era politicians. Everything was right or wrong, and there was very little in the middle. But anywho, Ereskin presents this lengthy speech to Parliament in support of his bill, and he largely agrees with Bentham on the subject of life. He says animals have no knowledge of the future, and their end, when appropriated fitly for our food, is without prolonged suffering. So what Ereskin here is saying, firstly, animals have no knowledge of the future. He's sort of looking at the consciousness argument and saying, well, do animals realize that they've been deprived of their tomorrows if we kill them today? Are we sort of depriving them future opportunities? All the things that we might say support a human right to life. And he's also saying, well, if we appropriate them fitly for our food, kill them in a swift and humane manner, we're ending their prolonged suffering. So again, Ereskin had no real problem with depriving animals of their lives. Where does this fit with the legal developments over the last couple of hundred years? Anyone who's looked at the statutory developments of animal laws since 1809 and 1822 sees that there's a clear lineage of developments of the law. One thing that was learnt from Ereskin's bill was that if you set your targets too high, you're going to fail. Ereskin's bill was widely opposed simply because it seemed to set its sights too high. It wanted to outlaw a lot of things that at the time were just too problematic, too contentious. So of course, we get to Richard Martin's, his famous bill in 1822, which was pragmatic. It was simply a recognition that certain of the practices that were taking place in Victorian Britain were worthy of prohibition, but it was going to be targeted, very focused. We'll focus on the overdriving of cattle, and not much more. We won't look at bull baiting, we won't look at bear baiting, we won't look at hunting, we won't look at any of these other things. It's about the overdriving of cattle, very strategic, very deliberate way of just getting some laws on the statute books which will deal with the first issue. And then we see an expansion. And it's unsurprising, by the way, that Martin didn't touch the issue of animal lives because, hey, far too contentious. So we get our first bit of statute. First statute, Martin's Act. Very limited. Pease's Act, I think, takes it to where, more likely what Ereskin had in mind. We increased the animals that were, the scope of the animals covered from being merely sort of cattle and agricultural beasts. We had a few more animals added to the list worthy of protection, and a few more situations. It wasn't just about the cruel and hard overriding. Things like duties became owed for in various circumstances beyond that. So it wasn't just about acts of wanton cruelty. But again, no mention really of lives. Because it's a natural progression from the Martin Act, which was a natural evolution of, I think, Bentham's utility principle. Then, as was the case, 14 years later, we had the 1849 Act, which is probably the culmination of the Victorian era legislation. And again, very much building on Martin and Pease, adding a few further provisions, but not really changing too much, updating it a little bit. And then by the time we get to the 1911 Act, and it almost embarrasses me to say, in fact it does, I was alive Not when the 1911 Act was enacted, by the way, but when this, and many of us probably were, when this was the 1911 Act was the operative act that governed animal laws in the UK. And the 1911 Act, if you look at it, it doesn't really do a great deal to add to those basic principles. There's a lot more in way of administrative justice and sanctions and so on and such forth. But if you're looking at what the 1911 Act actually does compared to, say, Pease's Act, it's more or less similar. And say, I was alive when the 1911 Act was still operative. 2006 Act, Animal Welfare Act, very much, here's the new dawn, here's everything that we've got so far amalgamated. Many commentators, I mean, you could look at the Animal Welfare Act and say, look, there's a lot of novel stuff. I mean, Section 9 in itself seems pretty novel. The duty of care under Section 9 is pretty novel. But you could say, well, all that the 2006 Act is an updated, slightly modernised 1911 Act plus its associated case law. Some of the key cases that were discussed in the latter half of the 20th century now seem to be sort of put on a statutory footing with the 2006 Act. So that's a long way round of saying, well, this is where we've got 1789, Bentham, trickles all the way through to 2006, 2021. Obviously, since 2006, there's been a couple of further statutory interventions. But at its heart, nothing's really changed in terms of the life issue. What has happened in the last 200 years of statutory development? Well, huge advances in welfare. So going back to Martin's Act, it was about prohibition of cruelty, absolute cruelty, wanton cruelty, overdriving of cattle. We started to have some welfare provisions introduced in Pease's Act, duties to distrained cattle, etc., duty to provide water, to provide shelter, etc. Certainly since the 2006 Act, far from perfectly, of course, we've seen huge advances in terms of welfare. I'm not saying by any means that where we should be or where most of us would want us to be, but certainly things like the licensed undertakings regulations, which say these are clear, specific welfare requirements under some specific circumstances, are pretty good if you, say, compare to even 20 years ago, perhaps. Huge increases in welfare, in the knowledge of what we must do to animals in order to protect their welfare, promote their health. No change in the life issue, going back to section 9.4. That's still the base point. Nothing has changed since Bentham in terms of the life. So does A, the massive increase in welfare measures, influence B? B being you can kill an animal humanely without any legal sanction. I'd say, well, if you go back to looking at what Bentham and what Ereskin were saying, yes, there has to be a necessary connection between the two. We'll come to that in a second, but just to pause on the issue of sentience. They're never worse for being dead. Now, back obviously in Bentham's time and Ereskin's time, 20 years later, we didn't know about the complex lives of animals. We still don't. Anyone who sort of says, I can tell you what an animal is thinking is just gifted. But we don't know about the complex emotional lives of animals. But what we do know is that they have some to some extent. Now, you might argue that this is anthropocentric, anthropomorphic, even when we're looking at our pet animals who are showing signs of happiness and excitement and looking forward. You might say, well, this is just anthropomorphizing. You're just kind of attributing characteristics, human characteristics, to this dog or You might look at an animal who's showing fear. The cattle in the line waiting at the slaughterhouse. Many studies will say, well, no, there's clear fear of the future, fear of the unknown, fear of what's happening, rather than just a sort of an absolute acceptance as to what's going on. You could say, well, this is about having a fear of the future, looking forward to the future, having some form of emotional life beyond the immediate. Now, I don't want to go into that because I don't know enough about it. It's biological neuroscientists, ethicists, far better people than I can do that. But what I have seen, of course, in reading around the discourse of animal protection, is that there are studies there which say that animals do have emotional lives, do have some conception of their own being, their own personhood, to use Joshua's phrase. What I think is more important, once we've established, well, we haven't established, but once we've suggested that this idea of their future means nothing to them is not really valid, because it probably does in some cases. Clearly there's a distinction to be made between Happy the elephant and, without meaning to be mean, an ant who's walking across the patio there, in terms of emotional intelligence, emotional life. But as a basic rule of thumb, we can say some animals clearly have emotional lives, but we'll leave that there. What for me is slightly more important is this welfare idea that because animals' lives were so abysmal and poor, the kind thing to do was to kill them. I would argue that given the 200 years of advanced welfare, we can't say that as strongly as we once did. We can't say that animals' mere existence is pain and agony, and a further day before they're sent to the slaughterhouse just prolongs this. We can say, well, animals are given fairly stringent welfare safeguards, on the whole. Wild animals, different matter. Domesticated animals, kept animals, companion animals, animals in farms even, we'll have a very quick look at aspirin in a minute, even animals in research laboratories have welfare requirements that might suggest that their life isn't just about pain, agony, and misery, and that they're experiencing positive things on a daily basis, and perhaps denying them those opportunities is something we could consider. And I just want to sort of more or less end on this point, which is hidden away in the Animal Scientific Procedures Act, as amended in 2013 as a result of the EU regulation that changed everything, whichever one it was. Huge changes in ASPA, the Animal Scientific Procedures Act, the statute that everyone knows ASPA. Everyone knows ASPA, don't they? Yeah, I'll take that as a yeah. This is the one that it governs all aspects of scientific procedures, entirely separate regime to the Animal Welfare Act. I think there's a petition going around on Twitter at the moment to say, well, surely animals involved in scientific procedures should be brought within the scope of the Animal Welfare Act. And part of me says, well, actually, no, please don't do that. Not that I'm a callous and hard person. I'm not a supporter of scientific experimentation, and it's not that I want to see the protections of animals involved in scientific experimentation watered down at all. But one thing in ASPA, which is not really, well, not at all, found in the Animal Welfare Act, is this notion here. 17A, you can tell it's one of the amended versions because it's 17A, it's been added in 2013. Setting free and rehoming protected animals. A person who holds a license must not set free a protected animal unless. And it goes on to say at 17A3, Secretary of State must not consent to the setting free or rehoming of a relevant protected animal unless. That, to me, is really significant. This unless phrase means that, for the first time, prior to this incarnation of ASPA, the end of protocol procedures were humane killing. Death as an endpoint. That was how animals were always dealt with when they were subject to invasive scientific procedures governed by ASPA. For the first time, it seemed that the government were imagining a life for animals beyond scientific procedures, almost as if their lives existed beyond their utility and had value in itself, that having been subject to these invasive procedures, having done their good to mankind, it's envisaged that they could move on and enjoy lives. Now you'd say, well, why is this the case? If their lives do not matter, if they were no worse for being dead, surely at the end of a scientific procedure, just euthanize them. That, I'd imagine, I haven't got any data on this, but I'd imagine it's still happening. But the mere suggestion that animals can have a life, something to be enjoyed after scientific procedures, suggests that from a legal point of view, we may be getting there. No such wording in the Animal Welfare Act, and frankly, I don't think it would be the case that the Animal Welfare Act quite yet would be ready to move to sort of get rid of Section 9.4. But I hope that if we keep asking questions about do animals feel, do they suffer, what is animal welfare about now in the 21st century, not by reference to the old Victorian times, then we might want to look at animals' lives and say, well, maybe they are entitled to a life of sorts. So thank you. Cheers.